Ladies and gentlemen, gentlemen and ladies, ladies and gents. This is to update you on all of the happenings. You know that it has been 14 months since I pointed out to people about performance contracts under UCC 9. The surefire way to make a contract binding is through voluntary performance. Do you all recall the New Hampshire House Bill 1778? It speaks about government and its deceptive contracts and their failure to inform respecting their corporate offers to contract. The government agencies have performance contracts and unilateral contracts, whereby you, by your conduct, are bound by the contract. Of first and foremost importance is the court system and a plea granting the court jurisdiction. This documents your submittal to the court's jurisdiction. The incarceration contract and its first 3 pages highlight this by actual case law I specifically found without looking to some document. The next is the DMV or other government agency's subscription through contractual application. Remember, you're applying and or subscribing is the nexus for jurisdiction. That's the word juris, my diction. Yup, the Matrix reference. 0HHEI, and if you talk about the Matrix, you are one of them. Yet we're talking about jurisdiction. The Supreme Court in 1824 stated that jurisdiction is the authority to act, the power to act, and without jurisdiction the party has no authority.
Rhode Island v. Massachusetts. The Federal Arbitration Act is the jurisdiction, the contract, the parties, the arbitrator, the courts, and the government all derive their authority from the Federal Arbitration Act. When a contract contains an arbitration clause and evidences commerce, this is money of any kind. Can an unsigned contract be enforced upon a party? Yes, if that party has knowledge of the contract and performs under the provision of the contract. Look only to New Hampshire House Bill 1778. Under general purpose, it speaks to such contracts introduced by government and the government organization, the state of New Hampshire's executive and legislative branches. States that corporate government has failed to inform the sovereign people, aka the common community, of the consequences arising out of these corporate offers to contract. Then there is restatement 2nd and 3rd of contracts, the Uniform Commercial Code Article 9-208. This is proof of the general and fundamental principles of contract law. But wait, your contracts are bogus, gobbledygook, nonsensical, frivolous, and meritless, as some judges have claimed. Does the agreement contain the commerce clause? That is, does it involve money? Does it have an arbitration clause? Then the court has no business even opening their mouth, as that is a matter to be decided solely by the arbitrator when delegated by the parties to the contract. See Shine v. Archer, decided by the United States Supreme Court on January 8, 2019. Did you know if the contract is challenged as a whole, it must be decided by the arbitrator and not the courts? The Supreme Court continues to state this, and the courts ignore the Supreme Court of the United States. They are afraid of their courts being less crowded due to parties electing to arbitrate rather than go through the court process that could take up to 20 years to complete. They are afraid of their power being shared by an arbitrator, so they attack the arbitration associations not of their own creation, where the arbitrator is not an attorney or an officer of the court. The arbitrator has the same power as a judge during arbitration. Arbitrators are immune as long as they follow the arbitration agreement and the FAA. So the courts have been permitting arbitrators and arbitration associations to be sued, despite their fundamental duty to dismiss these unconstitutional claims which violate the most basic principles of due process and equal protection of the law. The Federal Arbitration Act states that the court must grant the order to confirm the arbitration award. It states that the court must issue an order to compel arbitration when applied for. The Arbitration Act has only one provision for vacating an award under 9 U.S.C. Sections 10 and 11. Simply put, if the court does not find, by way of proof, that fraud has been committed by the parties, the arbitrator committed misconduct, that there is an obvious miscalculation in the amount awarded or the sanctions imposed, they are not permitted to vacate the award. Did you know that if the contract is challenged as a whole, it must be decided by the arbitrator and not by the courts? The Supreme Court continues to state this, and the courts ignore the Supreme Court. This view is an inverted exception, for the Supreme Court in Archer has made it clear that the courts must follow not the court rules, but the Federal Arbitration Act as written. So let's take a trip through the roadmap of the Act, shall we? The Act contains a total of 38 sections, which are divided into 3 sets of 16. The first 16 sections of the FAA apply to the contract that contains an arbitration clause and a commerce clause. Sections 201 through 216 involve state arbitrations. Interestingly, if the state arbitration contains a commerce clause, it involves money. It is automatically federal, and sections 1 through 16 apply. You know, many state judges fail to apply the federal provisions when state arbitrations have a commercial element, that is, involves money. Yet no one has told them to account, but after this, watch and see how often the state courts lose jurisdiction. The third and final section is also federal, but applied to international arbitration with or without a commerce clause. Let's begin with sections 1 and 2 of 9 U.S.C. This section states that if the agreement has an arbitration clause, which designates the determination by an arbitrator, then the FAA has the sole jurisdiction. The rules to be followed are the FAA, not the rules of the court, as this was the intent of Congress. The intent of the legislature. The Act prohibits the courts from claiming that the contract is invalid, revocable, or non-binding. Only the arbitrator may make such a determination. Sections 1 and 2 mention commerce. The Commerce Clause of the United States Constitution delegates that Congress has the sole jurisdiction over commerce, and they have written the FAA solely to handle contracts that contain both a commerce clause and an arbitration clause. Yes, this was documented twice, which was the congressional intent. Sections 3 and 4 pertain to the compelling of the parties to arbitrate disputes. According to the contract, the parties delegate that arbitration is the solution to solve the dispute. Sections 5 through 7 pertain specifically to arbitrators, their duties and qualifications, which do not say that the arbitrator has to be approved by the courts. These sections also do not state that an arbitrator must be an officer of the court or an organization recognized by the court and or established by the court's judges and or attorneys. Section 9 deals with confirmation and the time frame for contesting an award. The 1-year statute of limitations is the designated time in the FAA that a party has to confirm an award after it is issued. This grants to the court a statutory jurisdiction by stating that the court must grant the order to confirm. This is an obligatory duty. As the Supreme Court has stated, there's nothing malleable about must grant. If none of the exceptions in sections 10 and 11 are proved, not by the judge, but by the opposing party, then the judge has only one duty, and that is to confirm the award. Often parties do not know that the Act under Section 9 states that the party contesting the award has only 90 days from receipt of the award to bring for the challenge under sections 10 and 11. The Act provides, at this stage, no other avenue for challenging, contesting, or complaining. As you can see, a party has plenty of time to raise an objection. Originally, when they received the notification of arbitration agreement, when they receive notice of arbitration hearing, there is plenty of time for an objection to an arbitration hearing. It is to be noted that some arbitrators conduct arbitration hearings the way a court conducts hearings. In other words, at no party present. Hearing or de novo ruling can be determined solely based on documentary records. The Supreme Court has held such hearings as long as there is notice given prior to the hearing and due process is not violated. Therefore, there are many opportunities for an opposing party to contest. However, if the party attempts to contest past the 90-day statutory time limit, Their objections are irrelevant. This is stated in Section 9, and they would forever be time-barred. The courts have been permitting time-barred parties to bring challenges. This is a violation of the Act as written. The court must follow the Act as written, and the Act requires that the courts follow the contract as written. Such was the case in Archer v. White. People must appeal. They must challenge the court's ruling based on the court's failure to follow the Act as written. Under appeal, people need to challenge the court's jurisdiction. Now I have created a document that purports to do just that, which highlights the court's inherent jurisdiction over arbitration, limited to the Act as written and not Title 28 of the United States Code. The courts continue to treat arbitration as a lawsuit when it is clearly not. There is no controversy, as the contract containing an arbitration clause usually grants sole and exclusive jurisdiction to the arbitrator to hear any and all controversies or disputes. The Supreme Court in Archer ruled that the courts may only act when it is court business, and deciding controversies concerning arbitration is not the business of the court. The courts have a habit of not minding their business when it comes to arbitration. They are highly jealous of arbitrators, as they are selfish and they do not wish an outsider to have their immunity. The Federal Act grants arbitrators the ability to operate within the FAA. Also, courts do not want the corporations that conduct commercial business to be adversely affected. However, they have no choice. Why? Because Congress intended the FAA to give the courts a mandate to confirm arbitration awards and to put private contracts on an equal footing. This is why the Supreme Court in Randa Center v. Jackson and First Options of Chicago v. Kaplan stated that the FAA was created to place the burden jurisdiction on the courts to confirm arbitration awards. The courts suggest that it needs to be approved by some outside source. See was
Again, look at the Randa Center and First Options case law. When the courts make up a new rule that is not contained in the FAA, they are creating an exception which is prohibited. Note that the FAA contains no exception demanding one prove the courts have jurisdiction from an outside source, as Congress intended the Act to be self-contained. If this was not the case, the court would not need to say so, and we may not engrafting our only exception. Into the statutory text. Again, see the Archer v. White case, which quotes ExxonMobil Corporation 545 U.S. 546, 556-557, 2015. Do you get it? If a party had to rely on separate rules and/or statutes, Congress would have stated so. They would have stated the other laws that were applicable. The federal rules of civil procedure may apply, but only limited to their reference by the Act. Note, if the rules of civil procedure, which are added, amended and/or subject to revision generally applied, then the courts could create endless exceptions, thus engrafting the Act to suit their will and not the will of the parties. The exception is inconsistent with the statutory text and our precedent. Period. The courts must respect the party's decision as embodied in the contract. Period. We must interpret the Act as written, and the Act in turn requires that we interpret the contract as written. A court may not override the contract. A court possesses no power to decide the arbitrability issue. The court has no business weighing the merits of the grievance, because the agreement is to submit all grievances to arbitration, not merely those which the court deems meritorious. See Steelworkers, 363 U.S. 564, 568-1960. The courts know that Section 3 of the FAA provides that a court must stay litigation. This is also prevalent in the Archer case. This provides a definitive Stand your ground position on two issues. 1. That the court must is a jurisdictional and delegatory provision, and 2. A court must stay litigation. These concepts and case law proves that arbitration is not litigation. The rules of litigation and the fees for litigation are inapplicable. What has been happening is that the courts have been charging individuals the fee for a civil litigation action when the motions to compel arbitration, motions to confirm arbitration award, and motions to vacati, as prescribed by the Federal Arbitration Act, are all governed by the FAA exclusively. Neither requires the parties follow a separate statute, set of rules, or provide proof outside the scope of the Act. Now, many will want to go demanding that the court do this or that to correct the record. You can do that if you like, but it could also be a waste of your time. Please understand that you can civilly create a motion to correct the record. Title the motion, motion to vacate due to lack of jurisdiction, and or motion to reconsider and to challenge jurisdiction. The issue of contracts. Can you have a contract that is based on a template? Yes. Look at how all corporations use the same contract for all their customers and clients. When the names of the parties are added, it becomes a unique document. For instance, all birth certificates for the state say the same thing but when parties. Names are added, it becomes a unique agreement. Banks have standard promissory notes that contain the same lingo and become unique once the individual names are added to it. Attorneys are infamous for this. They do not sit down and create a new contract verbatim each time they have a new client. Get the point? Can a contract of the parties agree that the Earth is flat? That Columbus discovered America? That the moon is a planet? That a dog is a cat? That God does not exist? Yes, the parties can agree to anything. It may be a contract requiring a party to do the impossible, and not agreeing to do the impossible makes it invalid. For instance, a party cannot agree to turn water into gold, as that is impossible, because the two are made from completely different elements. Some will argue with this point, and if you are among the group, please avoid contracts, arbitration and the courts at all costs. You may only cause injury to yourself and others. What makes a contract binding, valid and irrevocable? Well, I shall discuss unilateral contracts. Here are the basic and required elements. 1. At least two parties with knowledge notice of the agreement. 2. That the agreement is doable and workable. 3. The agreement has a completion, expiration clause or date. 4. That there is consideration value in the agreement. 5. For the sake of FAA, it contains an arbitration clause. 6. That the parties performed under the terms of the agreement. Now some will say, look, your contract says and it states, does it matter what the contract says? For the sake of law, no. As long as it is agreed upon by the parties and is doable. Only the parties are affected. It does not affect the public and or public policy, as it is a private agreement. Now if it has a provision that does not affect the aforementioned, then it does matter. Background: on or about March 16, 2018, I was contacted by D. Hawkins, who was a party to the first incarceration contract containing an arbitration agreement. Congress was petitioned and a private law was passed, but not enacted, whereby Congress determined that the incarceration contract was binding upon the parties and the United States. Why was this significant? In 1925, Congress passed and President Coolidge signed the Federal Arbitration Act. The courts cannot overturn the act enacted by Congress and signed by the President. Back to D. Hawkins. When Congress held that the contract was valid, Congress had retrofitted that stance by overcoming a presidential veto with a 2/3 majority. The private law is not removed from the record as a national. Security matter, despite such claims as recorded phone calls to the government printing office and Rand Paul's office. Senator Paul sponsored the bill. Document. So for over 22 months I had made arbitration my main focus, and because arbitration has been around from the beginning, over 6,000 years, the FAA is the authority. Yet the U.S. Congress has provided strict regulations under the Commerce Clause. The issue was how to help the common folk, the common man, to apply the provisions of the Act to access redress. The government, through its employees, departments, agencies, officers, agents, etc., have been utilizing arbitration to their advantage. They have even gone to the extent of possessing arbitration associations. After some research, it was realized that there is no Federal Arbitration Act restriction on an arbitration association or neutral, or arbitrator, so I found an arbitration association. I participated in no arbitration as an arbitrator and cannot discuss my personal matters as to project the integrity of the arbitration process. It was anticipated that the American Bar Association, AAA, would challenge the arbitration association I founded. It was anticipated that the Judges Arbitration Association, JAMS, would challenge the arbitration association I founded, and true to their interfering nature, James did use its influence to interfere with our revenue to operate. The association I founded only acts as a process server and has no employees. Only neutrals who are not related to the agreement are appointed to act as arbitrators, so that there is no issue of fraud or misconduct. These organizations, Federal Reserve, Forum, JAMS, AAA and others, have attacked us. The courts have made no quorums about saying it is going specifically after SA, so we highlighted that the association only serves documents on parties. They went after our bank accounts and our merchant accounts to include PayPal and others. Approximately 7 accounts have been closed in a 3-month time frame. Why? Apparently, they intended to make it seem that the association was not well organized and not well functioning. We have an arbitration agreement on our site which has these parties agreeing to be bound by said agreement. They finally read the agreement and impacted our websites over 6 times. They have deleted over 40 gigabits of documents and changed links to direct people to JAMS. And as Morpheus said, we are still here. Some individuals have attempted to introduce their own contracts without including an arbitration clause. One such contract came my way, and the party, after paying $500, failed to provide a copy of the contract which included an arbitration clause. The arbitration was stayed for 10 days until he can provide a copy of what we asked for. People, it is your responsibility to make sure that you cross your T's and dot your I's, so to speak. The contract with an arbitration and commerce clause are of absolute necessities. Without this, the arbitrator has no authority, absolutely none. So knowing that the agents of AAA, JAMS, Forum and others would attack, I decided to do an agreement with the California Department of Corrections. That agreement included a double default provision that permits habeas corpus by arbitrator, which is binding on all parties. The state of California has defaulted. Look, as stated, people will start adding arbitrations to plea agreements and habeas corpus provisions to contracts. They will try to change the system. They will try to change the FAA. But for those whose contracts are complete and served on the opposing party, they are grandfathered in. They have gone after those who utilized contracts with government agencies, attempting to scare them with claims of fraud. The people do not know that claim of fraud must be proved. You can't merely state that she committed fraud. All the elements of fraud must be present. By the way, when the opposing party does a motion to vacate, you do a counter-suit, demanding a jury trial, and also do a demurrer. People will say, well, I don't know how to do a motion for a jury trial. All you do is get a civil motion template and fill it out as best as you can. Follow the format of the civil suit complaint with the parties' names being the same. You can add the judge's name to the list of the parties, as once a judge acts outside the jurisdiction, they lose their immunity by failing to follow the FAA or assuming the duties of the arbitrator by saying the contract as a whole is invalid, or the arbitration clause and/or the contract were never served on the parties are not the court's business. The judge is not protected by judicial immunity when acting outside the jurisdiction. The title of your motion will be Counterclaim Countersuit, Motion for Reconsideration, and Trial by Jury Demand. Your contract should have a tort option clause, so that you can bring such a suit after award or breach is documented. People ask, what if a judge levies sanctions against me? You must do the motion for reconsideration and challenge to the court's jurisdiction. By doing so, you bring forth legal challenges, federal questions, and when the judge denies you, as they will, due to hostility towards arbitration, you will then appeal, raising all the points he brought forth in your motion for reconsideration and challenge to the court's jurisdiction. Look, they have everyone and everything figured out. They threaten you, you panic, get scared, that you react. You can't react, as you have to be prepared to. Act and plan ahead. As stated, the jurisdiction is 9 U.S.C. not Title 1, 28, 42, 7, or 14. Title 9 U.S.C. is a boundary marked out by statute. Make them play within their boundary and between the lines. The courts have planned that you all will not appeal their bogus orders because you don't understand the rules. Okay, first, the appeal for all matters concerning the arbitration is the only provision where the rules of the court may apply. Read 9 U.S.C. Section 16. How do you file an appeal? First of all, file the motion for reconsideration, and after the court denies you, then file a notice of appeal. It's just a motion titled Notice of Appeal. The body only has to say Notice of Appeal, and you will sign and date it. Yes, the motion that only needs 6 words. On appeal, the focus on challenging the court by stating the same thing contained in motion for reconsideration and challenge to the court's jurisdiction. Tell the appeals court that the trial court erred by failing to follow the FAA as written and failed to maintain the FAA jurisdiction. That there is only one statute that applies to federal arbitration, and that's the FAA. The courts have no latitude to create exceptions or reasons for denying requests that are not listed in Section 10 or 11 of the Act. You explain to the appeals court that the trial court's judgment must be vacated and the matter returned to that court with instructions to proceed within the confines of the FAA. We have recreated a reconsideration and challenge template. It is attached to the site on SAA Limited. Feel free to utilize this document that has been designed to kill the presumptions of the attorneys who attempt to change the subject. Do you not see? They have nothing. They can't say they did not get notice. They cannot say that the contract does not contain a valid arbitration clause. They cannot say that the FAA does not apply, and despite the fact that they cannot say these things, they will attempt to, while you argue with their presumptions. People in arbitration, they must prove the burden is on them. Do not allow them to switch it to you. All this time, these agencies, attorneys, judges are attempting to overwhelm people by filing document after document, suit after suit. First, the contract prohibits this activity. Second, they are not only time-barred as a result of the 10 to 20 calendar day embedded in the contract, but also the statutory 90 days to contest the award. It is called res judicata. That simply means that if you have a judgment from one court, you can't go to another court of similar jurisdiction to obtain a different judgment. An appeals court is not a similar jurisdiction. The arbitrator and judge have same power and immunity under the law, so if a party refuses to respond while having a duty to respond after receiving notification, is in default or breach of an agreement. And after receiving notice of arbitration hearing, choose not to purchase date, or after receiving award with more than 90 days to contest, under The FAA, they are forever time barred, are stopped, and must accept their fate at all hands of the record. Even if the court could somehow stay the appeal, it possesses no delegation of constitutional authority to dismiss an appeal without due process of law, of the land. So I decided to accept the attempt to change the terms and conditions by doing a conditional acceptance of agreement. The new agreement was sent to the First Circuit Court of Appeals, the Administrative Office of the United States Courts, and the United States Attorney General, as representative of the United States. I supplied proof that the government may enter into commercial agreements the same as a private person, and that by entering into such a commercial agreement these parties did so waiving any and all claims community. Everyone, the law is founded and based upon principles. Arbitrators derive their authority to resolve disputes only because the parties have agreed in advance to submit such grievances to arbitration. See AT&T Communications v. Communications, 475 U.S. 643, 648 to 649, 1996. Because the plaintiff's offer clearly provides a mechanism for rejecting the offer, the respondents had a reasonable opportunity to reject plaintiff's offer by defaulting on their obligation to respond, as respondents had a duty to respond. The default, although willful, constituted assent per terms of the agreement. The respondent's conduct is not actual silence. Silence constitutes acceptance. C. Hill v. Gateway 2000 Incorporated 105F. 3D 1147-1149, 7th Circle. As the court noted in Gateway, the Hills admitted to receiving the form contract but failed to read it. Where a letter is properly addressed and mailed, there is a presumption that it reached its intended destination in usual time and was actually received by the person to whom it was addressed. See Hakuna v. United States, 286 U.S. 427, 430, 76 L. ed. 861, 52 as. Court 417-1932. The court must presume that a letter properly addressed was received. See Godfrey, 997 F. 2D 335, 338, 7th Circuit 1993. The reason for that is because the United States guarantees the delivery of the mail through rain, snow, sleet, and hail. Many are not getting the Federal Arbitration Act as it is in outline. The rules and procedures are embedded within the text, which is why the Supreme Court states we must interpret the Act as written. Many an attempt by clueless, learned fellows of admission, and thought that they could go to the court to seek an injunction against an arbitration award. Not so fast. That is not an option under 9 U.S.C. paragraph 910 and 11. When you do a motion to confirm, the only defenses are in 10 and 11. Don't believe me? Go and reread. Section 9, which states that the only exception to the court must grant confirmation award, is the exceptions listed in 10 and 11. Again, if they claim fraud, fraud must be proved and the burden per the FAA is on the defendant. So stop thinking you have to defend yourself. You can write a motion letting the court know that the option to issue an injunction is only provided under Section 16 of the FAA. As the limits placed in Sections 9 through 11 do not include the challenge to bogus, nonsensical, unintelligible, or a word-placed contract. A contract may not be challenged under 9 U.S.C. Section 9 unless it is procured by fraud that is proved by evidence. The only other challenge is obvious misconduct or an obvious miscalculation that appears on the face of the document. These are the limits the court is stuck to being confined, and no further movement is provided under 9 U.S.C. paragraph 9, 10 or 11. So if the challenge is made to the award during a petition to confirm, you must then let the court know, not by inciting or insisting, but by stating clearly that the court possesses no jurisdiction for making such or considering such. As an exception, or the avenue for such a request is only reserved at Section 16 of the Act, and even then within the constraints of the Act Sections 1 through 15. You must challenge the court's jurisdiction without being confrontational. Yes, they will be confrontational, so you just make your request and explain that the governing rules are the FAA, that the rules and the court only apply under a limited provisional set of the FAA. Yet under so if the court refuses to follow the act as written and that was an effective date of issuance of award, then I have no choice but to challenge the court's jurisdiction. Remember, no one can get upset for your exercise of the right, and if they do, just state I put you on notice that you are interfering with my free exercise of a secured right. You are in violation of your oath of office. I must ask you to cease and desist. Any further breach of agreement will result in contract provisions being strictly applied. Many of you are scared of the court's raids challenge their jurisdiction because you're not sure of what will happen. Well, by law, jurisdiction may be challenged at any time, and jurisdiction once challenged must be proved to exist. All the courts notice and most will ignore your challenge. If they do, by law, they are without jurisdiction. That means that when the court fails to prove its jurisdiction, it has none until it proves it. Now I did not make this up. See Rhode Island v. Massachusetts, 1824. If you challenge the court's jurisdiction, what's the worst that could happen? You get thrown in jail? They take away your rights to every challenge again? They revoke you or you to access? Or they ignore you and you get used to such a violation on appeal? They are more worried than ever, because people can utilize contracts to compel performance of government agencies such as prisons. And why not? The contracts work as plea agreements, whereby you agree that what they did was legal, lawful, and right, yet only if they can prove it by certain claims and documentations. Now we have the Supreme Court stating that in the first instance this should have been the only issue. Could the court order a party to arbitrate or compel when the contract clearly did not delegate such authority to an arbitrator? Now Archer and Light Sales did not stop there, as they opened the door for all of us. They argue that the dispute was not subject to arbitration because the complaint sought injunctive relief. People, do you not see? Injunctive relief is for an arbitrator to decide. Read the syllabus, it is right there. So all of you who have attorneys asking for vacating an award outside the exceptions of the FAA or who seek declaratory injunction relief. The Supreme Court of the United States has stated that a party to an arbitration contract has delegated all disputes to be resolved by arbitration. Is not the business of the courts to interfere. Injunctive and declaratory relief is a question of arbitrability, not a federal, legal or judicial question. The courts may not override, overrule and or decide any issues concerning challenges to the contract as a whole, or to arbitrability. They simply have no power, no authority, no goal being business messing with the arbitrator's business. The court must mind their own business. On the jet fuel dump, what was not said? Delta Airlines pilot dumped jet fleet fuel on a populated area, not by mistake. He was not lost and he knew his altitude as he got permission. People. Since 911, do you for a moment think such would be a violation of the Patriot Act and or the EPA? The FAA rules do not permit. Has the pilot been suspended or fired? I just have questions. Why would they do this? Wrong question, the wrong angle. Everyone should read the hazardous label at the gas pump. The next time you're pumping gas, you will see that the fumes have been documented as cancer-causing. The people were deliberately poisoned, and that's what the suit should be about, as these hazards are listed on the plane as well as the truck, the storage tank. They all have warnings of exposure. Was exposure long enough? Who can determine such? So a class action will be next in discovery, depositions, policy, review charges, firing of plane personal flight crew. Yeah, let's see if these people get some payback for not respecting their lives. It's about more than just school kids, these were whole neighborhoods. Message for mothers for housing. Mothers, I am sorry. You were onto something. However, you failed to create a bill, so all of the work you did on the house, from sweeping, nails in wood, to gardening, you now need to document. Find the code, the enforcement code, that speaks to keeping property clean, grass cut, trash cleared, neighborhood beautification, and then send the bill to the company that is evicted by you. By law, you can make a claim. Be reasonable and then you should file a lien on that property. Proof of your work, proof of mailing your bill, and any pictures that you have which documents your work. Give them 30 days to pay and also charge them for moving expenses as they were to pay outstanding debt prior to the eviction. You did the work and can prove it so they don't go to When just because they say so. Now, mothers for housing, please pay attention. The proper way to do adverse possession is as follows. First, you must understand the purpose, origin, for adverse possession. It was during the time the United States was formed. There was a lot of free open land, and they needed people to inhabit it. Remember the Gold Rush and Hidalgo Treaty? In both instances, people went to squat on land and put up their posts in the four corners to stake a claim. This is also known as adverse possession and is lawful. Modern-day adverse possession contains a great deal of misinformation out there. Each state has statutes on adverse possession. Some are between 1 to 5 years, while others are greater than 20 years to get a title. There's a much more simple way. Let's outline it and please do your research. Do not go and ask an attorney if you can do this, as he, by law, cannot tell you, and his response will be quickly a no. You find an abandoned property and you do a quick observation of the property to make sure it is truly abandoned. No electricity, no furniture, the yard is unkept, trash, weeds, and or junk. You start to clear away trash, junk, weeds, etc. Yes, it's a job. Not all in one day, of course, but perhaps over a period of time. You have a right pre-code, city and county code on sanitation, trash, infestation, clutter, fire, hazards, etc. You are assisting the government in maintaining a habitable state. You can use your phone to take pictures before and after, and you post a bill at the front door or mail it to the property, metered mail, and keep a copy of your receipt addressed to the property owner, not the occupant. The following week you do the same as you continue your beautification program. Feel free to plant flowers and paint, but you may not enter the property just yet. Also, do not show up in just some car. It should look like a work vehicle, as there should be a business sign, business card, garden tools, and at least 3 people. You can put your labor costs on the bill, and the fees must be reasonable, as similar to the going rate for like services. You will send this property 4 bills over the course of 4 weeks, taking before and after pictures each time for your proof and records only. You will, for the sake of the law, send a second letter to the same property address to yourself and complete the change of address with the post office for yourself only. The 3 people or your associates should be present and assisting you, so that no one can claim you're doing something illegal. You must have a copy of city, county, and state codes for upkeep of properties, yards, infestations, etc. Now, you are on your 4th week and have gone to Home Depot or Lowe's and purchased locks for the doors. Now you can, after the mail is received in the 4th week with your name on it, enter the property. As the law says, as long as you receive mail there and can prove it, the owner must use the court to evict. You have a presumed active right to be there. By now you can get the electric turned on in your name, the water, trash, cable, etc. Document all costs and work. Now with the 4th week complete, you have sent a default notice. The labor documenting hourly fee is not more than $60 per hour plus equipment rental. The Home Depot has pricing, and your hourly rate should be at 15% more only. Over time, we can see surcharges, garbage disposal, supplies, and now you should understand. Slow down, many of you have gotten ahead of yourselves. Remember that this is a job, so you are not doing this for a home, but to keep the area and the neighborhood clean, safe, and habitable. That is why you do everything by the book and do not skip a step. Now that you have sent the default letter to the owner, also known as the property owner, at the last known address, include a copy of all previous bills with debt. Collection notice. Download the script on the debt collection that complies. This is an attempt to collect a debt. Check out the FDCPA and maintain compliance with that. You'll receive a knock at the door, a public officer from the police department. He will claim that you are trespassing, and this is why you waited the 4 weeks, did the work, and created the bills. sent them by mail, provided proof of the mailing, the utility bills, these all give a presumption of residency. They will have no choice but to attempt to convince you that you can and will go to jail if you don't leave. You will simply reply, not according to the law. I have provided proof of residency. Now if you're attempting to evict me, where's the court order? Why did I not get a hearing before judge? If they keep insisting, ask for a watch commander and do not argue. Do not answer irrelevant questions. Now the court is involved. You will put your bill, state laws, pictures, proof of mailing to the property owner's last known address. As you counterclaim, before they can evict you, they must by law pay the reasonable portion of the bill. Mothers for Housing did not mess this up. They did not bill the property owner, and they need to sue for unlawful eviction and failure to offset the debt. But how do I get a home? This only shows me how to state a claim. This is why you look for property that is truly abandoned, because after 2 months of billing, the owner will go to court and do a writ of possession for the property due to the debt. You may place a lien on the property, but you must follow the rules and attach a bill. If property is truly abandoned, when you go to court, you by now have pulled a copy of the title to the property, and you will have to serve the person named, as you are not required to do this until after you have repeatedly mailed to the last known to you. Address, which is the property address, which is why you mail to the property owner and not a named person. The same as a coupon company's junk mail is sent to the property owner on the title, to the property owner. Occupant or resident, and to the person named on the title at the address of the property, to the person named on the title at the address, mailed to the address on the title. Most of the time after service, and follow the rules and proof of service. Yes, you have to do your homework. This is not free and was never meant to be free. If you do the work and document everything, and you will win. At the very least, you will get reimbursed. The party does not show up on a default and the court issues a judgment for a writ of possession of property. If the party shows, then you have your debt, proof of non-responding to bills, letters, and not keeping the property up to code, which is the issue. The usual way of adverse possession is you can only do one home, as everyone has the right to one home. Adverse possession usually permits a person to adversely possess only one home, as it normally requires one to be in the home for years and continuously. However, you can occupy 2, 3, 8 homes at one time through adverse possession. Some have thought, wait, that means that Donald Trump, as an example, cannot own more than one home? So I will go to adverse possess his vacation home. Oh hell no. You can't do that, as adverse possession does not work that way. The law does not work that way. Life does not work that way. However, you can beautify the community, keep property free of debris, vermin, pests or rodents, document pest control, fire hazard control, repair, upkeep, etc. According to the code which you have looked up and called to ask some, I quote, where the code located for the county, state, city, is there more than one code enforcement agency that requires property upkeep? The property be free of the debris, trash, rodents, weeds and overgrowth. Eventually they will stop answering your questions and they will start asking you question the flight. Why do you want or need to know? Then he will get stupid. Many of you will get attitude. For what? Simply state, I'm just asking as a citizen of the state, and by law you are required to directly to this information. They will direct you to some website or building. Your reply is, I'm disabled and I do not have the internet available at this time. Wait, what's your disability? What's my disability? Why does my disability matter? Are you attempting to use my disability to deny me service in violation of the ADA? Well, everybody has access to the internet. Are you calling me a liar? Let me speak to a supervisor. I need to file a complaint for discrimination. And follow through. If you have to file a complaint, file a staff complaint or grievance. If you have to file an appeal, administrative appeal, and file an appeal, none of this is complicated. It only appears that way because you're unfamiliar with it. So as you follow through, you pull up rules, go to YouTube, watch videos on the process. Look, I am doing all I can to help the many. All I can to prove that arbitration as it is law today is the only feasible way out. It is streamlined and quick. For instance, the courts have said that the redemption coupon contract is just a piece of paper, junk, and they do not get to do that. The coupon has value and consideration built in. It is an assignment of interests and parties have a prior relationship, therefore it involves commerce, book entry credits, as an arbitration clause, is between competent adults, has an expiration date, is doable, workable. This is what gives the contract value. Whose job is it to make such a determination? You will say the arbitrator, but it is the parties. As long and so long as the parties have agreed, the contract is valid, irrevocable and enforceable. Unless one of the limited exceptions of 9 U.S.C. Section 10 or 11. Get familiar with that section, please. Take it extremely literal and as written. And the arbitrator will settle any controversy between the parties respecting the agreement. Please go over this information until you understand it. Yes, over and over and over again. That is for your benefit, not mine. I say show me anyone who understands the FAA and performance contracts better than I, and I will show you a liar, a fraud, an idiot, for there is no one alive